Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, bringing it to you from Chicago, Illinois.
Hello, and welcome to Planet Lex. We're podcasting from the Northwestern Pritzker School of Law in Chicago. I'm your host, Vice Dean Jim Speta. Joining me today to discuss Northwestern Law's Bluhm Legal Clinic as it celebrates its 50th anniversary, as well as the importance of clinical legal education more broadly, is Tom Geraghty. Tom, thanks for coming in.
Thanks for having me.
Tom is the class of 1967 James B. Haddad Professor of Law. Tom was previously the director of the Bluhm Legal Clinic from 1976 through 2017, as it grew from a few lawyers and some passionate students to one of the premier clinical programs in the country, housing more than 20 clinics in 13 centers. Tom has also worked internationally on clinical legal education and access to justice issues, particularly in Ethiopia, but also in Tanzania, Uganda, Southeast Asia, and a number of other locations. In 2016, Tom was honored at UNICEF's Chicago Humanitarian Awards for his work on juvenile justice issues abroad. Thanks again for coming in.
Glad to do it.
So we're about to celebrate the 50th anniversary of the clinic at Northwestern Law School, but you've previously written that clinical education at Northwestern actually goes way back to the early 1900s and was started under our famous Dean John Henry Wigmore. What was Wigmore trying to accomplish in the early 1900s in setting up a clinical experience at Northwestern?
Well, I think Wigmore had two concerns. One, he was very interested in what we would categorize now as social justice issues. He was interested in the treatment of individuals in our Cook County criminal justice system. He was also interested in how workers in Chicago post-industrial revolution were being treated by the companies for which they worked, particularly children. So the two clinics that he started, one focused on representation of defendants out at the criminal court buildings in Chicago, and the other focused on representation of individuals who had been injured on the job or who were not receiving proper benefits from their employers, especially those working in heavy industry. Those would be adults, and then children who were working perhaps in textile mills in Chicago.
Sounds like it was well within the context of the progressive social movements of the time.
Yes, absolutely. And Wigmore was a reformer in the sense of worrying about those kinds of issues that were present in Chicago during his time. And he was very interested in making sure, even requiring, that law students came in contact with folks in Chicago who were experiencing the environment of those days, particularly lack of social services, lack of adequate justice in the criminal justice system, and then, of course, treatment of workers.
You've written that Wigmore often drew an analogy from medical education to the way he thought about clinical legal education.
Exactly. Yes.
Do you think that analogy holds?
I do. I think, as a matter of fact, what we've tried to model in our clinic, and as a matter of fact, the origins of our clinic go back to the time when Jack Beckstrom and Tommy Evaldi, two emeritus professors at law school, started the clinic. And the original idea was what they called one-stop shopping, so that patients who came into the Northwestern Medical Facility clinics who had legal problems could be referred to the clinic at the law school. Those problems would have included issues involving obtaining proper public benefits, eviction cases, minor criminal matters. So that's the way the clinic actually started, as sort of what we would call now a medical legal partnership.
You're referring now to the clinic as it began in the late 1960s, not Wigmore's
exactly
clinic.
Right, yeah. So when the clinic started, sort of started up again in the late 1960s, the idea was a medical legal partnership with the medical school. But going back to what you asked about Wigmore's interest in making sure that students were involved in and exposed to clients, actually, he thought that was the kind of experience that they ought to have to make their legal education more meaningful to them, and also to engage them in a lifelong commitment to serving the underserved.
Between the time of the late 1960s, when the clinic as we think of it today started, and you played a significant role in that, and Wigmore, there was a fall off in clinical legal education at Northwestern.
Yeah.
Did that reflect something of the time or just something of the personnel or something of legal education in general?
Well, I think it reflected something about legal education in general. I think after the 20s and going into the 1930s, the law faculty and its deans became sort of more inward focused. They were focusing on the development of legal doctrine, the examination of legal doctrine. I think they thought that the proper role of legal education was to engage students in the classroom, not necessarily on the ground, experiencing life as it exists outside the law school. And as a matter of fact, the funds that had originally been allocated or earmarked for establishing a clinic and maintaining a clinic here at Northwestern, which was actually quite a substantial sum, was given by a very prominent industrialist back then. Those funds were, I would say, I'll use the word in quotes, diverted to support the more traditional aspects of legal education, and the clinic sort of fell by the wayside.
So was that the landscape that you faced in 1967 as you and others started to think about a new kind of legal clinic for Northwestern?
That was the landscape, although there was one course when I was a student here beginning in 1966 that was called Legal Clinic. It was taught by one of our alums, a fine gentleman named Henry Keno. And that legal clinic course consisted of a large lecture once per week about a subject relevant to legal aid. And then we were all required to go down to the Legal Aid Bureau to interview clients. And Mr. Keno would comment on our interviewing technique, and that would be it. I mean, we would have one contact with a client, and we would try to provide meaningful advice, and then who knows what would happen after that. Hopefully the legal aid lawyers there would take over. So that was the landscape when I was in law school. And
so that wouldn't be clinical education as I've experienced it or as we practice it here, where students actually have as individuals clients, represent clients, go to court or engage in other proceedings on behalf of those individuals.
That was a sort of a general education course in what we might call poverty law and some exposure to clients. So what we thought as students then was missing was the actual engagement with clients, the actual engagement with issues that were affecting those clients. And so a group of students and some faculty members got together and found funds to start what we call an in-house clinic. It began with a director whose name was Gary Lazar, who went on to teach at Chicago Kent. And there were 2 full-time lawyers and maybe 15 students to begin with in the fall of 1969 when the clinic first opened its doors.
The late 1960s was the time of the civil rights movement in the United States. Did that context play part of the background or part of the role in this thinking, sort of similar to the way the progressive movement was a background for what Wigmore was trying to do?
Absolutely. The civil rights movement and the Vietnam War were sort of catalysts for the kind of activities that the clinic became involved in. So while we started with the basic kind of legal aid case, it could be an eviction or a divorce or a public welfare administrative hearing, we went on to begin to represent community groups who were advocating for change. We became very interested in the way that the criminal justice system in Cook County affected poor people. And we also became interested in how the juvenile court was functioning, particularly as it dealt with young children charged with serious crimes. But going back to the community groups, I mean, we represented back then groups ranging from the American Indian movement in Chicago to some of the members of the Black Panther Party. We were involved with some of the investigation into I would call the murder of Fred Hampton.
Yeah.
We got involved in the representation of some young members of organizations that are now referred to as gangs that were just starting out in Englewood and on the north side of Chicago. So, and this was generated by the student interest in trying to figure out what was going on in our communities and how we could provide legal support that would help them move along in ways that would be constructive for their communities.
Seems to me at the time, in addition to representing many civic or social organizations, there was also a deep partnership in the work being done by the clinic with other organizations that were trying to address similar social issues in the city. Is that right?
Yeah, there was a deep partnership with what is now the Legal Assistance Foundation of Chicago. As a matter of fact, the Legal Assistance Foundation of Chicago posted a couple of lawyers in our clinic. And we worked with the Legal Assistance Foundation of Chicago very closely, particularly in the area of public benefits. We did a lot of welfare, what was called welfare litigation. We did a lot of consumer protection work. Actually, Tommy Evaldi was in charge of that aspect of the program. We did some bankruptcies. So we had a very comprehensive program, but we always reached out to the existing service providers, and also we made a great effort to involve our alumni and a number of cooperating law firms in the work that we were doing.
In 1976, you became the director of the clinic. What did it look like at the time?
The clinic was in the basement started out in the basement, as many clinics did. Those who might be listening to this who were in clinical education at that time had a common experience. We always seemed to be in the basement to start with. So we were in the basement of what was then existing Thorne Hall, which was essentially a large cathedral-looking building on this site that we're on the site of the Rubloff building now. And we were in the basement of that building. It was built out with some very rudimentary offices and a student work area. And then over the years, we sort of worked our way out of the basement into the second floor of Wiebolt Hall, which was originally the business school down here, and then into the McCormick building, and then finally into this magnificent space that we have now on the 8th floor of the Rubloff building.
What was the size of the clinic in the mid-1970s when you took over?
I would say, well, we had, I think I recall 6 lawyers, and at any one time, maybe 50 to 60 students.
Was the work still very much the same as it had been?
The work evolved. I mean, and we were for quite a while sort of eating what we could kill in terms of funding. So we had funding to do, for a while, we had funding to do special education work. And John Elson led that work and filed a lawsuit against the Chicago Board of Education, the Corey H. case, which has been tremendously influential in increasing the availability of special education services in Chicago. So we had that project. We had an employment discrimination clinic that was led by Roz Lieb. We were also beginning to really focus heavily on what was going on in our juvenile court, because it was, at that time, it had been founded with great fanfare at the turn of the century, but it had really fallen into disrepair. And because so many of our clients were experiencing what I would say is uneven justice and very poor service there, we decided to focus on improvement of the juvenile court in our clinic.
And in fact, that was the very first of the centers that you built in the clinic.
That was that was the first center, the Children and Family Justice Center, that was funded by the MacArthur Foundation initially. And the whole idea, I recall making a presentation on this to our faculty, our law school visiting committee, and this was actually to Judge Sophia Hall as one of our graduates. She was a member of that committee. And I suggested that we adopt a court, using the, terminology that might be used in children's law, and help to improve that court, which I think we did. We were able to work with another of our graduates, Judge O'Connell, who understood what we were trying to do and actually started to put judges out there who were the best of the circuit court's judges instead of the judges who weren't so good when we started. So together with him, the Children and Family Justice Center, I would say, had a lot of input into making our juvenile court work a lot better, primarily through effective judicial leadership and also convincing judges that juvenile court was a place that they would want to serve and that they should aspire to.
It seems that this sort of became a model for many of the other centers or projects that you had in the clinic, a combination of representing clients in incredibly meaningful individual matters, but at the same time doing advocacy and really work on structural reform issues.
think the idea there was to have a menu of cases and projects that were meaningful for our students, in which they could make significant contributions, but also always to learn from our clients and to learn about the issues that we ought to be focusing on as a result of the work we were doing on behalf of our clients. So, for example, when we would be asked to represent, let's say, a 13-year-old charged with a murder, we could begin to understand and examine the laws that related to the treatment of children in that kind of situation, whether they should be tried as juveniles or adults, whether they should be sent to the criminal justice system or remain in the juvenile court. When we actually experienced what it was like to represent those kids and got to know them, we became convinced that this was an area that needed some attention and some change, and that 13-year-olds should not be sent to the adult court to be tried. And there were many examples like that.
So it's how you see this interaction between representation in individual cases and more structural issues.
That's right. And so students would be involved in both. I mean, they would have the opportunity to represent individual clients, and then they would have the ability to see how those clients were being affected by then existing rules, practices, laws, regulations, and so forth.
Seems to me a similar story could be told of one of the other centers that came a few years later and has received a lot of publicity throughout not just the nation, but the world, is the Center on Wrongful Convictions.
Yes, and that had an interesting genesis. Larry Marshall, who was then one of our colleagues here at Northwestern and was teaching federal jurisdiction after a clerkship with Justice Stevens, became interested in a couple of death penalty cases. It turned out that those cases involved clients who were actually innocent. At the same time, I'd been appointed by our Illinois Supreme Court to represent a couple of clients who told me that they had been tortured by Detective John Burge. They had been electroshocked. And we started to work with Larry, and Larry, of course, led the way with the tremendous work he did in organizing the center and putting on this tremendous conference that he put on, which drew tremendous national and international attention to the problem of the death penalty and the wrongfully convicted. We continued to develop that center. Larry was instrumental in doing it, but we also, one of the things that he did that was so effective was to convince some very experienced post-conviction lawyers, Jane Raley and Karen Daniel, to join our office. And their skill and dedication helped us develop the capacity to really effectively represent those who had been wrongfully convicted. I should also mention Rob Warden, who was the executive director of our center, who was a journalist, who was tremendously skillful in getting out the word about the importance of this issue, the issue of uneven application of the death penalty, and the fact that many of the folks on death row in Illinois were actually innocent. Rob, as executive director of the center, got the word out about that along with Larry. And we were also able to draw a lot of the most experienced and well-known and highly respected lawyers in Chicago into that center as collaborators, as members of an advisory board. And it became a terrific educational program for our students and provided incredible service to our community and to our country, and I think set an example for folks around the world who care about the importance of accurate fact-finding in criminal justice.
And just like as in the context of the children court, led to some significant legal reform here.
Yeah. It did. First of all, it resulted in some changes and focus on the way that police interrogate suspects and witnesses. There was a tremendous amount of attention on forensic evidence. The unreliability of eyewitness identifications was examined, and reforms were made in that area. The use of accomplice or jailhouse snitch testimony was brought to light, and there are now some laws that deal with, in Illinois at least, deal with what the state has to show in order to be able to even call what we would refer to colloquially as a jailhouse snitch.
And finally, to the moratorium on the death penalty.
Yeah. To the moratorium on the death penalty, and I think ultimately to the abolition of the death penalty in Illinois. That was all the work of the of our Center on Wrongful Convictions, again, with the support and collaboration of a lot of other lawyers in Chicago and throughout Illinois who were drawn into the process. It was a tremendous experience to be able to work here at Northwestern with people like Larry, Karen, and Jane, and others, Steve Drizzen, and also to work with the fantastic Chicago legal community on these issues. Ultimately, for example, in the case of the Area 2 torture, we were able to collaborate very effectively also with one of our, I think, most distinguished alums, Flint Taylor, who's written a really interesting book that just came out about 6 months ago called The Torture Machine, in which he documents his work in that area and also on other civil rights cases. So it was just a fabulous experience to work with so many talented lawyers, and it gave me, and it continues to renew my faith in the in legal education, the importance that it has in developing people who do the kind of work that we do in the clinic and that our graduates do and continue to do in collaboration with us.
You mentioned that at each of these stages, even the highest profile cases, students are involved.
Yep.
And you've described the way in which the faculty as lawyers and the students work together as the colleague model of teaching. What did you mean by that?
Well, what I meant by that, and what I continue to mean by it is that when we take on a case, no matter how big or how small, and of course, every case is important to a client, so I shouldn't characterize as one is big and one is small in terms of its importance. But we work with students as colleagues, and we're with them every step of the way. We are there for their first interviews with a client so that we can provide feedback about how they're doing. We obviously carefully review any written work that they're doing and go through multiple drafts of all written submissions. When we go to court together. We never send students alone to court, and have them come back and tell us what it was like. I mean, we're there with them, not because we have any lack of confidence, in what they're going to do in court, because we've carefully prepared them, but we want to be able to provide feedback, and you can't do it unless you were there. And we want them also to take responsibility. So when I tell them, okay, this is your case, it is your case. I mean, you're going to have to be making the decisions, but we're going to talk about the decisions that have to be made. And ultimately, I think the most important product that a lawyer has to sell is judgment. And we're hoping that process develops the student's judgment. If they're put on the line and they have to make a recommendation to a client about, well, do we plead, are we going to go to trial? Are we going to plead guilty? Are we going to take a bench trial? Do you want a jury trial? Should we file a motion to dismiss, or should we not file it at this point? Should we engage in plea bargaining or not? I mean, these are decisions that lawyers have to make on a routine basis based on their good judgment. So we want our students to have the experience of making those decisions with us, and we share the responsibility. I mean, ultimately, we are responsible as lawyers. We wouldn't want anyone to go into court for a trial or any kind of proceeding or in any kind of setting without full-fledged, adequate, the best representation. Sure. That's what we want to model. That's what we think students will learn best from.
And I think the work that you personally have done and the clinic has done has been a model throughout the nation. You don't have to comment on that. You can just let me
well, thank you.
Let me say that. But you've also worked hard to bring clinical legal education to the rest of the world. You've had a many-decade partnership with schools in Ethiopia, but in many other countries, in Tanzania, in Southeast Asia, as I've mentioned. Does clinical legal education around the world look different from what we experience here in the United States in general, if you can generalize on that?
Yeah. Well, we've done a lot of work in this area, but I would say that the clinical education movement as a whole in the United States has been tremendously influential in this area. And there's an organization called the Global Alliance for Justice Education, GAGE, which is run by a fellow named Frank Block at Vanderbilt, who has focused on just what you're talking about. And I've had some experience working on my own in Ethiopia, as you said, and I have some sort of general overview of clinical programs developing in the countries that you've mentioned, in addition Myanmar, Vietnam, Thailand, and Ghana, also the Gambia. So various places. So one of the struggles that the clinical programs in those countries that I've worked in are, that they're having involves the same kind of struggle that we had when we started clinical education in the United States. When I said we, when the modern era of clinical education started in the late 1960s, and that is that law schools in these countries are quite traditional. They teach according to the lecture method. There's very little interaction in small groups between faculty and students. It's very hierarchical. And there's no incentive for law school faculty to do the kind of thing that we and others, started back in the 1960s. So the challenge is, well, how do you? But there is an incredible amount of student interest. So how do you create and maintain a clinical program in a law school where all the incentives are, as far as the faculty is concerned, traditional scholarship, getting an LLM and a PhD, and not being actively engaged in practice. As a matter of fact, in Ethiopia for a long time, faculty members were not permitted to practice law. And there are some schools within Ethiopia where they're still not permitted to practice law. So who's going to staff the clinics?
In some countries, they're very clear that law professors are government employees. So the notion of doing some of the work we think of clinics doing is forbidden because they're part of the government.
Yeah, that would be a conflict. Yeah, so how do you run a criminal justice clinic in China, for example, or in Ethiopia, because you would inevitably run up against the government, and the government is funding and running all of the law schools in Ethiopia. So that's another challenge. But all of these challenges, I think, are being worked through, and you can see some slow but positive developments. There's in Ethiopia's case, clinical education has been written into the national curriculum of Ethiopia. Every law school has to teach according to a national curriculum, and there are now about 35 law schools in Ethiopia. And so while the clinics may not look like ours in terms of staffing and the kind of work they can do, they still can involve students in direct contact with clients. So students have the ability to meet with clients in mostly civil cases. They have the ability in some areas of Ethiopia, and Uganda, for instance, has a very good student practice rule. And some of the law schools, some of the regions within Ethiopia have student practice rules as well. But it's a continuing I think there's a real thirst for figuring out how to involve students in more small group practical experience settings. And I'll say also that in these countries where I've worked, there's a legal aid is not generally available. They don't have large legal aid, government-funded programs. So the legal aid that is provided is often provided by the universities and by law schools. And the universities take this on. They say that this is our responsibility to do this kind of work, which is a little different than what it is in the United States, frankly. I think you'd get a lot of different answers according to which university you were involved in as to whether the provision of social services or legal aid is or should be part of a law school's mission.
Coming back to our law school and coming back to the question of now and the future, what do you see as the next wave or opportunities for clinical education here? We've mentioned some innovations. One of the innovations that we didn't mention was the starting of the Entrepreneurship Law Center, called at the time Small Business Opportunity Clinic. And so I would say one of the things we've seen in the last 20 years of clinical education is more transactional and business clinical education. Do you see other similar developments coming in clinical education these days? Well,
I should have mentioned the Entrepreneurship Center because it's been tremendously important to our clinic and to our students and to our law school's community. Very, very, very popular and effective program. I continue to think, and I struggle with this, that the most important lesson that we can provide our students still and on an ongoing nature is ongoing processes, being exposed to the troubling issues of the day through the experience of our clients and having a lot of interaction with our clients who are in distress, whether they're being evicted from public housing, whether they're sitting in the juvenile to temporary detention center or the jail, whether they're in a drug rehabilitation program, whether they're experiencing difficulties in getting their public aid benefits. I continue to think that kind of contact is the most important kind of activity that we should provide for our students. While the entrepreneurship and the technology areas are areas that our students are interested in and probably will be most involved in when they graduate, I think that the unique contribution that a clinic within the law school can make is just what I've described. And I think the challenge is going to be to see whether that view is accepted or not. I mean, I think it's right now sort of up in the air whether my view on this is something that will, is what others would agree it should be the focus of our mission. And, that is as it should be. I mean, after a certain period of time, the younger group has to take over and has to decide, well, what is it that is most relevant? And just as we did back when we, started the modern, or some of us were involved in starting the modern era of clinical education, I think, and that's a good thing, But I'd be hopeful that focus would, of contact with individuals and learning how to relate to clients would remain the focus, because I think it's not only important for our students to have that background as they go forward in their legal careers, but also, it does develop skills that that students really need to have. I mean, I'm always sort of amazed when a student does a first interview. There are some exceptions, but the process of interviewing is something that needs to be taught, and and that you need to know how to deal with the clients that we relate to, but also if you're working with an entrepreneur or a CEO, you have to know how to gather information in a conversation, and that's something that I think we teach very well, but is not sort of appreciated to the extent that it should be as an important skill that you can develop in law school and then use going forward wherever you go.
Well, thank you for that, and thank you for your thoughtfulness, and also thank you for what you've built here. We are so happy to be celebrating our 50th anniversary of the clinic as we now know it, and your 42 years at the helm have been a big part of that. So thank you for coming in and talking to me today.
Well, thanks for having me. I appreciate it.
So that's our show for today, and I appreciate everyone out there joining us. If you like what you heard, please subscribe and rate us on Apple Podcasts. I'm Jim Speta, signing off from the Northwestern Pritzker School of Law.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.